in this session, we will discuss the topic of remand. Remand, which is also popularly known as pre-trial detention. So, when an accused is detained in custody, whether it is police custody, whether it is judicial custody, but that detention is done even before the trial has commenced. That is, even before the police has completed its investigation and submitted their challan, or which is commonly known as charge sheet, with the judge. Before that, when a person is detained in custody, that is known as pre-trial detention. So, section 187 of the Bharatiya Nagarik Suraksha Sanhita deals with remand. It has replaced the erstwhile section 167 of the CRPC 1973. So, section 187 of the Bharatiya Nagarik Suraksha Sanhita 2023 pertains to the period of remand which can be granted by a magistrate when an arrestee is produced before him by the police. This provision has set at rest the legal debate as to whether the maximum permissible 15 days police remand can be granted only in the first 15 days, or it can span over the entire period of 60 or 90 days of detention, as the case may be, provided for investigation for the purpose of default bail. Viewers, in an independent country like ours is a welfare state, the law is required to zealously guard the personal liberty of every individual. In our constitution, rights are sacrosanct and we cannot tolerate the detention of any person without legal sanction. The right of personal liberty, it's a basic human right. It is recognized by the General Assembly of United Nations in its UDHR, which is the Universal Declaration of Human Rights. This right has also been prominently included in the Convention on Civil and Political Rights, to which India is a party. Our constitution also recognizes this fundamental right in Article 21, which provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Thus, personal liberty being the cornerstone of our social structure, legal provisions relating to arrest and detention, they've got special significance and they've got special importance under our criminal laws. In criminal laws, what is at stake? Life and personal liberty. Okay. A person who is convicted of a heinous crime may be sentenced to death also. Even otherwise, a person might be arrested, put behind the bars. So, when the stakes are so high, that is, a person can be deprived of his life or of his personal liberty, then Article 21 has to be kept in mind, that is, no person to be deprived of his life or personal liberty except according to procedure that has been established by the law. And whereas do we find this procedure? Earlier it was under the procedural law related to crimes, which was the CRPC of 1973. Now the CRPC being replaced by Bharatiya Nagarik Suraksha Sanhita of 2023. Now the relevant provisions relating to procedure established by law, they are to be found under the provisions of the BNSS. Then Article 22, Clause 2 of the Constitution of India provides that any person arrested and detained in custody must be produced before the nearest magistrate within 24 hours of his arrest, and no person can be detained beyond the period of 24 hours without the authority of magistrate. See, sanction from an appropriate judicial authority, that is the magistrate. It is mandatory if you want to detain a person beyond 24 hours. Similarly, Section 58 of the Bharatiya Nagarik Suraksha Sanhita, which was the old 57 under CRPC, it states that the police officer who arrests a person without a warrant shall not detain him in his custody for more than 24 hours without the special permission of a magistrate under section 87 of the BNSS, which was old section 167 of CRPC. So, this special permission, which has been referred to in section 58 of the BNSS, is known as remand. The power of a court to remand an accused to custody is governed by a number of provisions under the BNSS, such as sections 187, section 232 and section 346. Now, each of these provisions is independent of the other and comes into play at different stages of the criminal trial. The remand under 187, it relates to the stage of investigation and is ordered for furthering the investigation and can be either in judicial custody or in police custody. The remand under section 232, it relates to the stage when the magistrate commits the case. So, he can remand the accused to the custody during and until the conclusion of the trial, subject to the provisions of bail under the code, and finally, remand under section 346 relates to a stage after cognizance where accused can only be sent to judicial custody. Now, the question arises, how long can a police officer detain a person without remand? So, as per section 58 of the Bharatiya Nagarik Suraksha Sanhita, the police cannot detain any person in its custody for more than 24 hours. The law prohibits a police official from detaining the arrested person for more than 24 hours in police custody. This period of 24 hours in police custody is exclusive of the time that is required for transporting the accused from the place of arrest to the court of magistrate. In cases where investigation cannot be completed within 24 hours, then it is the duty of the arresting officer to produce the accused before the magistrate. So, you see, either you complete the investigation within 24 hours, otherwise there is a duty that has been imposed on the arresting officer that you cannot keep a person who has been arrested in your custody beyond 24 hours unless and until it has been authorized by the concerned magistrate. The purpose behind imposing such a condition is to ensure that people are not unnecessarily harassed by being arrested and detained for the purpose of extracting confession or as a means of compelling people to give information. And at the same time, we also need to afford an early recourse to judicial officer independent of the police on all questions of bail or discharge. So, there has to be a balance between the rights of the arrested person and also the rights of what we call as the police to have a fast arrest of the accused person to ensure that investigation can be started timely. But here the foremost consideration is, if a person is being deprived of his liberty, then we need to have a recourse of judicial officer to a judicial officer who is independent of the police, and he can take care of all the questions whether the accused has to be released on bail or not, and we have to rule out the possibility of the person who is being arrested of being in any way harassed or detained or tortured for the purposes of extracting any confessions or any information by compelling those persons to give information against themselves. So, in order to rule out all such possibilities of abuse of powers by the police, such kind of a condition has been imposed that within 24 hours they have to produce the arrested person before the magistrate. Now, coming to the question of remand and what can be the duration of remand, there have been multiple judgments of the Supreme Court. Now starting with the decision of the court in CBI versus Anupam J. Kulkarni, this is a 1992 judgment in which a two-judge bench of the Supreme Court had held that maximum permissible 15 days of police remand can be granted only in the first 15 days of remand. Then later, a two-judge bench of the Supreme Court in CBI versus Vikas Mishra, this is a 2023 judgment, took a contrary view and observed that the decision of Anupam Kulkarni, that is 15 days remand should be in the first 15 days. Now, in this CBI versus Vikas Mishra, the Supreme Court took a contrary view and observed that that decision of Anupam Kulkarni requires reconsideration. Then in August 2023 itself, a two-judge bench of the Supreme Court in V. Senthil Balaji versus State took note of the difference of opinion among various judgments, and while agreeing with observations in Vikas Mishra's case, they referred the question to a larger bench. Now, in the meantime, what has happened? From 1st July 2024, BNSS has come into operation. So, with the enactment of section 187 of Bharatiya Nagarik Suraksha Sanhita, the reference to a larger bench of the Supreme Court has now become infructuous, as now the legislature has itself dealt with this issue. So, what does the statute say? Section 187 of the Bharatiya Nagarik Suraksha Sanhita provides that the maximum permissible 15 days of police custody can be granted in the whole or in parts at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days as the case may be, as provided in subsection 3. Under subsection 2 of section 187, the magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or doesn't have any jurisdiction to try the case, he may, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, he can authorize from time to time the detention of accused in such custody as such magistrate thinks fit, for a term not exceeding 15 days in the whole or in parts at any time during the initial 40 days or 60 days out of the detention period of 60 days or 90 days respectively, as the case may be, as provided in subsection 3. And if he has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, then he may order the accused to be forwarded to a magistrate having such jurisdiction. Under subsection 3 of section 187, the magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period exceeding 90 days, where the investigation relates to an offence punishable with death, imprisonment for life or imprisonment for a term of 10 years or more, and 60 days where the investigation relates to any other offence. So, you see there are these two categories. So, when the investigation is concerning an offence that carries a higher punishment, such as punishment that exceeds 10 years or life imprisonment or death penalty, then total maximum period of detention can be 90 days. In other cases, the maximum period of detention can be 60 days. And on the expiry of the said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail. See, look at the language of the legislature. It uses the term shall. So, what it says is, that is on the expiry of 90 days or 60 days as the case may be, the accused person shall be released on bail if he is prepared to and does furnish bail. So, this condition is obviously there, that he must be prepared to furnish bail, and then every person who is released on bail under this subsection shall be deemed to be so released under the provisions of chapter 35 for the purposes of that chapter. So, viewers, a careful perusal of section 187 reveals that the bar of maximum 15 days of police custody within the first 15 days from the time of arrest has been removed now. So, this permits the magistrate to order police custody for a period of 15 days, and this 15 days could be any time during the initial 40 or 60 days of detention. Further, section 187 subsection 4 provides for a check on the abuse of power. It says, no magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in custody of the police. See, there is a possibility of the police abusing its powers, and during interrogation sometimes they may torture, physically also abuse the accused person. So, to rule out any sort of harm being inflicted on the accused person who is in the custody of the police, what does the law say? That whenever the police seeks an extension of the remand, then the accused has to be mandatorily produced before the magistrate in person, whether it is the first time and whether it is on any subsequent occasion, but every time. Whenever they demand an extension of the custody with the police, every time the accused has to be mandatorily produced in person before the magistrate. But when we talk about judicial custody, then what does the law say? The magistrate may extend further detention in judicial custody on production of the accused either in person or through audio, video, electronic means. So, in cases of judicial custody, even if you produce the accused through audio, video, electronic means, through video conferencing, that is also okay. The magistrate may not necessarily insist on physically producing the accused in front of him, but when it comes to police custody, the magistrate will insist on the accused being produced before the magistrate physically the first time and on every subsequent occasion also. So, you see, for police custody, the accused has to be produced before the magistrate physically every time, but for judicial custody, accused may be produced via video conferencing too. So, all this has been done with an objective to minimize chances of custodial violence. Further, subsection 5 of section 187 BNSS prescribes that no magistrate of the second class, not specifically empowered in this behalf by the High Court, shall authorize detention in custody of the police. Then there are explanations also appended to this provision, which read, explanation 1. For the avoidance of doubts, it is hereby declared that notwithstanding the expiry of the period specified in subsection 3, the accused shall be detained in custody so long as he does not furnish bail. See, although after the expiry of this period, the accused has the right to be released on bail, but for that first the accused has to furnish bail. Then under explanation 2, if any question arises whether an accused person was produced before the magistrate as required under subsection 4, the production of accused person may be proved by his signature on the order authorizing detention or by the order certified by the magistrate as to production of the accused person through the audio, video, electronic means, as the case may be. Now, let us talk about the concept of default bail. So, viewers, default bail, which is also known as statutory bail, is a type of bail which is a right to an accused who is detained in custody when the police fail or are unable to complete the investigation and file the charge sheet within the time frame stipulated under the law. So, you see, this is a provision which strikes a balance between the rights of the victim and the rights of the accused person. See, the victim has a right to register an FIR, get investigations done against a person who is accused of committing a crime. But at the same time, investigation, they just cannot continue for ages altogether. It has to be completed in a time bound manner, because during investigation, where required, the police has a discretion to arrest the accused person. So, when an accused is arrested, when he is behind the bars, he has the right to be released on bail if the investigation is not completed within the prescribed time period, which could be 60 days or 90 days depending upon the gravity of the offence, depending upon the imprisonment which that offence would entail. So, the police is also supposed to act promptly. Where required, they have to conduct the preliminary inquiry within 14 days, and thereafter they have to start the investigation and also complete the investigation within 60 or 90 days as the case may be. See, if they have committed a delay in conducting the investigation, why should the accused suffer for that? So, the accused has a right to be released on bail where investigation it cannot be completed within the stipulated time. So, after the completion of that stipulated time period, the accused gets a right to be released on bail, and that is known as default bail or statutory bail. In the case of Central Bureau of Investigation versus Kapil Vadhavan, this is a January 2024 judgment. There was a bench of Justices Bela Trivedi and Justice Ujjwal Bhuyan who held that statutory right of default bail cannot be availed by the accused once the charge sheet is filed against him. Also, accused cannot seek default bail merely because investigation is pending against another accused or charge sheet is incomplete. So, you see, if investigation has not been completed within the specified time period, accused has a right to be released on default bail. But if investigation has been completed and if the police has filed its report, then in such cases, if there is a case which is being made out against the accused person's prima facie, then he might be denied bail, then his detention can be continued. See, the objective behind grant of a default bail under section 187 subsection 2 of the Bharatiya Nagrik Suraksha Sanhita 2023 is to encourage speedy investigations and protection of rights of accused should the investigating authorities drag their feet, because investigations should also be conducted within a time bound manner. So, if investigating authorities, they are not acting with promptness, unnecessary delay is being conducted, then no accused can be deprived of his right to liberty. The investigating authorities cannot be permitted to deprive the accused of personal liberty by securing remand, while also making no headway into the investigation into the commission of the offence. An accused should not be deprived of such benefits merely based on a preliminary charge sheet that was filed as a formality and does not disclose the commission of an offence. Equally, an investigation may not immediately reveal the full extent of the offence, but a preliminary charge sheet may disclose the commission of a cognizable offence which the relevant court can take cognizance of and set in motion the criminal process. Therefore, courts could consider whether the police report, commonly referred to as the charge sheet, filed within the 60 to 90 day period serves its intended purpose that is whether it adheres to the requirement of section 193 subsection 2 and presents sufficient materials for the magistrate to determine whether to take cognizance of the offence. If an offence is disclosed and cognizance is taken, then issue of default bail no longer survives and the grant of bail ought to be subject to the regular provisions. The judgment in Ritu Chhabdiya had laid a blanket proposition that a charge sheet cannot be filed without completing the investigation without reference to purpose of a charge sheet merely on the ground that investigation was still pending. However, in Kapil Vadhavan, the Supreme Court considered the necessary requirements of charge sheet. Since the requirements were met and charge sheet was filed within the relevant 60-90 day period, no default bail could be granted. Hence, in the matter of default bail, rather than solely considering whether the investigation is entirely complete, the key consideration ought to be whether the charge sheet is filed within the prescribed 60-90 day time period and materials produced with the charge sheet disclose the commission of an offence. Materials produced with the charge sheet should be sufficient by themselves for the court to take cognizance under the applicable section. Thus, default bail may not be granted if these conditions are met. So, viewers, this will be all for this session. Thank you.